coffee. Coffee sounds delicious, Bobby. Don't put anything spicy in it. Just drink coffee. All right, all right, all right, all right. Everything looks good. We did it. We are on August 17th. Ah, darn. YouTube hates me. We are on August 17th. Then it skips right away to August 21st. Hold on, I gotta scroll the whole way back down. Alright. And then 21st, 22nd, 23rd. And then it skips to the 25th. And then boom. We're on August 28th. 29th is when the fireworks begin. Let's get there.
This is a murder case, and that is what should drive all of us in terms of the ascertainment of truth. I mean, this is a serious matter, and at what cost do we deprive the jury of the full opportunity to help ascertain the truth? They are the fact finders.
Let's put this cost issue to rest. The court was advised that if the court gave adequate notice to both the Sheriff's Department and the Los Angeles Police Department that no overtime personnel would be used, it would be all on-duty persons who would be regularly scheduled to conduct for example, the LAPD Metro unit that would do the escort duties and the traffic control, they would all be normally assigned and on duty at that time, so there's no additional cost to the taxpayers. The only additional cost that the court may incur as a result of this is there is temporary fencing at Bundy that will have to be removed and replaced. There is a minor electrician's job with regards to the Malibu lighting. So my guess is we're talking expenses somewhere between $200 and $300.
Very well, Your Honor. We'll put that issue to rest. The one remaining thought I have that I would like to...
Which I'm sure Mr. Darden will be happy to front for us.
No objection. All right. Very well. There you have it.
It's in the record.
Your Honor, my last observation for the court is this. If a picture is worth 1,000 words, then a view is worth 1,000,000 in these circumstances. And I'm asking for the court to allow us the originally anticipated opportunity to balance the views with daytime and nighttime. If we proceed only with the daytime view, as instructive as it is, it still leaves the jury with an impression of how things looked during daytime. We need to balance and temper that with the nighttime view, and my concern is that we don't want to leave the jury with a misleading or inaccurate impression regarding the lighting. The very preview of the defense argument offered by Mr. Douglas today, in my mind, is just adds further strength to the argument why this view is necessary. We can work to make it substantially similar. We can have the dry run so that we have at least agreement as to how the view should be conducted, and that conditions are indeed substantially similar. And again, Your Honor, we ask that the court allows the opportunity to take the jury to Bundy and Rockingham at night so that we can achieve that. Thank you.
All right. Thank you, counsel. I agree with you, Mr. Hodgman, that a picture is often worth 1,000 words. The problem with nighttime photography, there are certain limitations to nighttime photography. It's dependent upon the film speed, the film type, the aperture, the exposure. Any number of adjustments to a camera can result in a different final result as printed. So although the crime scene photographs of that evening are certainly illustrative and useful, they don't capture the actual scene as can be appreciated by the human eye. And the human eye's ability to appreciate or not appreciate under these circumstances certainly is an issue. I will conditionally order the nighttime jury view for Sunday. This is conditional on one more walkthrough. I'm concerned, I share Mr. Douglas's concern. My greatest concern are two things: establishing for the record the nature of the overhead street light, and I think we have Mr. Hernandez available. We've almost used one court session for this issue, so when I take the recess, I'll allow Mr. Douglas, Mr. Hodgman to speak to the city lighting person. If we can't resolve that on the basis of the records that we have, we'll take some testimony. I'm also concerned about the landscape light that was originally designed to shine up on the street number 875, but the testimony was that was canted slightly to the north. If that can be replicated, if that cannot be replicated, then we will not have a nighttime view, because that is a crucial lighting source that was within mere feet of the Nicole Brown Simpson.
Smells like a bar.
Yes.
That the front door was ajar.
Yes.
Certainly there were lights that were on, and all the lights were on in the house, and candles were lit.
If you recollect, there were two lights that were on downstairs. I think our chart does have the two interior lights that were on. Also, the overhead light over the door was on. So we'll have the door open, we'll have those interior lights on. That's in the chart. I hadn't heard any dispute about that, so I assumed that that was the condition. All right, as to, also, during the dry run, my understanding is that the Taylors, their regularly scheduled gardener, is going to be doing some cutting back of the foliage. The court will examine that as well on the dry run to see if that substantially replicates. If the court is satisfied at that time, then we will go forward. If not, we'll cancel. Also, during the dry run, Mr. Douglas, during the course of our dry run last Sunday, for the first time while we were standing at Bundy, Mr. Scheck mentioned to me, for the first time, a defense desire to have this sound demonstration. Looking at the photograph that Mr. Byrne has brought out, the complication would be that we would have to close that alley for a significant period of time, and that would be great inconvenience to the residents there since they would be denied access to their homes. But it's something that we will have, I think logistically we can do. We will have to ask the senior lead officer in that neighborhood to go out and advise the residents that that's a possibility, in fairness to the residents, because we may block off their alley for an hour. It's something I'm willing to contemplate, assuming I'm convinced that the conditions are substantially similar. However, just by glancing here, I can see several metal gates across the street on Bundy.
The court will recall, of course, that on the first...
But what I'm indicating to you is I'm willing to contemplate this, and we should probably take it up in the field and make a determination at that time.
I'm mindful that on the first jury view, the alley behind Bundy was cut off as well, as
Well-
were the streets on both sides.
They were, however, we're trying to do this with as little inconvenience to everybody as possible.
I appreciate that, Your Honor.
All right. But what you're talking about is having to have an additional 2 cars to cut off the alleyway.
Your Honor, with regard to that, as the court has correctly observed from viewing the aerial photographs, there are a number of metal gates. I hold in my hand in excess of a dozen photos of metal gates from that very immediate area. And if we are going to engage in such a venture, we would ask that similar slamming of other gates as well, so that we don't, in a sense, sort of a gate lineup. But that, and that,
Well, don't we
therein
have a
lies part
Taylor
of the
problem?
problem
We have a
with this.
Gilbert and Taylor problem?
But we will have the investigator who took these photos, and so
Mr.
we're in a
Hodgman,
position
I
to point out
indicated
the
to you,
defense
I'm
in the court.
aware that there are a number of metal gates out there. They brought up this issue. Since we're going to be there, I ought to at least give it some consideration and think about it. If
Very
it's
well.
plausible, if it's something that's reasonable, something that might help the jury decide this case, I'm willing to contemplate whether we should do it. We're talking maybe an additional half hour to walk everybody around to that location, slam a bunch of gates, and see what happens, see what they can hear.
Your Honor, it's clear, I think, even the people know that you can hear it. They did the same test themselves.
Well, Mr. Douglas, we'll argue it after we've had a chance to go out, because we did not inspect the rear alleyway or do anything while we were there. All right. The point being, I'm willing to contemplate it. All right, let's take a break for 15. Let's have the jury brought down. Mr. Hodgman and Mr. Douglas, I'm going to instruct you to talk to Mr. Hernandez, who is here with his street lighting records. And if we can't resolve that matter by an agreement, then we'll take testimony. Ms. Clark, you had something, and Mr. Bailey, you had something.
Yeah, very, very briefly, Ron. Mr. Hodgman alluded earlier to the fact of a judicial notice motion. I have the copy that is stamped that the original was filed on August 14th, and this is the request that the court take judicial notice of the phase of the moon on the night in question. We have appended to it the records that we premised the request on, and I believe the court did its own research of that same topic. We would ask that the judicial notice be taken on, I guess, either today or on the day that we go out to the jury view, that the jury be advised of the judicial notice taken of that information.
All right, Mr. Douglas.
Your Honor, there's one important word or consideration that was omitted, I think admittedly so, from their own papers, from their judicial notice. The nature of the crescent moon was a waxing crescent moon. Waxing means increasing, as their own dictionary reference suggests. If we don't use the word waxing, and I suggest that we not, we should use the word increasing to at least give the fair sense of the nature in which the crescent was appearing that evening.
Got no problem with that.
I do. The counsel is going to seek to create an impression with his jury that it was actually brighter than the judicial notice would give reason to indicate. The point is the condition of the moon on that night, whether it was going to increase the following day or going to decrease the following day, because waxing indicates what will happen in the future, not what's happening on that night. On that night, this was the condition of the moon. That's all the jury needs to
But
know.
isn't waxing and waning a rather commonly understood term with regards to the phase of the moon? Don't you think the jury can figure that out?
They may, but the point is that it's irrelevant. It doesn't matter. Really, waxing refers to what's going to occur. It doesn't matter. It doesn't matter. If the moon was going to get brighter at a point in time later that night, after which the events are no longer an issue, what does that have to do with anything?
The problem is, it is a fact.
It is a fact.
If I accept your offer of judicial notice, it's the truth.
It is the truth. But
And the jury has a modicum of common sense, I assume, and life experience, and they understand what a waxing and waning moon is. So
they probably
I'm
do.
likely to accept, I'm just telling you, I'm likely to accept the accurate description. All right?
As opposed to just taking judicial notice of the percentage crescent that it was?
Yes. In addition to.
Right, in addition to.
In addition to.
Yeah.
All right, Mr. Bailey?
Mr. Yokelson and I went up and visited with Judge Reed, who's finished instructions. He will be finished. He will be finished with the original tapes today. He's listening to them all, and suggests that for convenience sake, since he will not need them again, they be returned to Ms. Robinson, and that Your Honor issue the order releasing and then retrieving them from the laboratory, which we hope will enhance them and make them easier listening both for yourself and ultimately for the jury. So if that's satisfactory, Your Honor, we'll prepare such an order, and when he returns the tapes to you, we'd like to pick them up and take them over and have them worked on.
All right, Mr. Yokelson?
Yes, that's fine, Your Honor. It's my understanding from Mr. Bailey and from speaking with the defense that the defense has never had in its possession the original copies of these tapes. It only has a copy that was provided by Ms. Schwartz, by Mr. Schwartz. If that is correct, we would like to ask that we get a copy of whatever was provided to the court before it's released to Mr. Bailey, and we can cooperate in making those copies.
Mr. Bailey, any objection to that? So they have a second.
My understanding is that they have what we have, both furnished from the same source.
But the problem is we're assuming that that is what was provided to the court, because neither party has seen the original tapes. So we're simply asking that copies of those originals be made for both sides.
Well, let me see if I can understand and explain, Your Honor. They got what we have, because I had the lawyers bring the originals down and deposit them with you the other day. Before that, the tapes that they tried to subpoena and seize, that was a copy made from those tapes, maybe a second, third generation tapes. I understand that when Mr. Schwartz gave them the same thing last weekend, he gave them the same thing we had.
But I suspect, well, Mr. Yokelson, how long do you think it would take to copy these tapes, given the fact that your sound lab has high-speed duplicators?
Your Honor, it would take us a matter of hours, and the point has to be made that before these original tapes are examined and perhaps altered, a record has to be made of what they were, and that's what we're asking.
I understand your point.
Mr. Douglas was indicating that the high-speed dubbing may very well add to the distortion. So all we're trying to do, and what Mr. Bailey was doing, was to go up and ask. We found out last night that you can clear up substantially the background noises I told Your Honor, and it'll make it easier for Your Honor and Judge Reed to hear this once this is done. And
No, I understand that, but Mr. Yokelson's point that there ought to be one copy, at least, of the tape that is in existence before any enhancement activity takes place, that probably ought to be made and lodged with the court in case there's any dispute as to how or what happened. And if Mr. Yokelson has as an officer of the court, if he has the ability to do that in this building in an expeditious manner, I'm inclined to order that.
well, and I don't want to speak cynically, I don't want any of these tapes erased or anything. I want to make sure that the court,
Well, we'll make sure that we punch out all the, I take it somebody's already taken the effort to punch out the copy protection.
Well, I don't know if they've done it on the originals, but we'll have to see.
We'll
I'll
do
make
that.
sure that that's done.
And, Your Honor, we'll invite a representative of the defense to be present during the copying procedure.
I was about to suggest that. All right, you can take Mr. Blazier with you.
Mr. Volunteer, Your Honor, leaving. I think he may be gone.
No, I had overheard that he had travel plans.
Mr. Bailey, perhaps
All right.
Mr. Bailey or one will do next one.
We'll deal with this tomorrow after Judge Reed.
All right, I understand you gentlemen can figure this out.
We should work this out.
All right, thank you. All right, we'll take a 15-minute recess, and Mr. Douglas and Mr. Hodgman, would you consult with Mr. Hernandez, and if we need to take some testimony, we'll do that at 10:15. Douglas and Mr. Hodgman. There's Mr. Douglas. Mr. Douglas, did you have the opportunity to confer with the gentleman from the Department of Street Lighting?
We did, Your Honor. Thank you. Following our discussions, Mr. Hernandez, who was quite cooperative, was unable to confirm specifically that the two lights in both locations are in fact identical to as they were on June the 12th. As the court will recall, we were informed by the police that a specific order was made to change the lighting given the problems that was attendant to the influx in traffic with tourists and foot traffic. And though he was able to check and verify a certain number on the outside of the light bulb, he did not actually remove the casing and check the bulb itself. He will do that today, and he will be available on Friday, assuming we go back out to the scene. And if in fact there was a change, it's been agreed, though we still reserve our objections, that he will then make the appropriate changes.
All right.
We don't have the representative here, Your Honor. I know you're going to address it with Mr. Douglas now, but the representative from our office that talked to Mr. Hernandez with Mr. Douglas is not present, so we don't.
Well, I accept Mr. Douglas's representation that the bulb will be checked to see if it matches what's supposed to be there, and if it's different, it'll be changed to what it was supposed to be.
No, I'm not.
I just said I accept your representation, Mr. Douglas, is what I just indicated.
I was only indicating to the court that we can't offer any further information.
All right, so it's one more thing I have to hold until tomorrow. All right.
There's one other thing that if I might just want to point out, that we got a number of calls, this is from Professor Dershowitz, regarding this high-speed tape reproduction. And these are supposedly experts in the field who stated that if one does a high-resolution, high-speed tape reproduction, the very likely result will be significant distortion in voice inflection, word loss, et cetera, et cetera. And this is not a necessary method to duplicate these tapes. And so I raised this because we've gone to a lot of trouble. This is very important. And I don't want to have these tapes altered or...
Your technical expert, Mr. Bailey, wanted to say something to you.
Sure, sure. I understand it's apparently worked out. I didn't want to make sure it wasn't done by people who didn't understand. Apparently they worked it out now, and it's going to be okay. Thank
All
you.
right, thank you. We'll leave it to the experts in their respective fields. All right, anything else we need to discuss before we resume with the jury? All right, let me ask one other question. What is the possibility of having witnesses available tomorrow?
I'm glad you asked that question, We've thought long and hard and tried to do everything we could in this connection. But the court, I think, is aware that we're at the point of the tapes. Quite frankly, the witnesses after that, the court knows who those witnesses are. There are several witnesses in Chicago, and there's Mr. Weitzman, as I indicated, all of whom are not available at all this week. We just could not get them. So we have Mr. Aguilar, or hopefully we can finish him by lunchtime.
How about Mr. Regals?
Mr. Regal, as the court is aware, Mr. Regal is being handled by Mr. Blazer. As part of our order, he will come right before Dr. Henry Lee. And Mr. Blazer, as you know, because of the previous commitments, will not be here this afternoon or tomorrow either, Your Honor.
Well, I could change that.
You certainly could, Your Honor, but I think we're not ready yet. He'll come right before Dr. Lee, I think, the court pleases. And that's the problem. So we have tried very hard not to have any downtime, but we need the time for the tapes. We're at that point in the case, and we did lose some time by people's motion. So I wanted to let the court know as soon as possible, so perhaps the jury can have some kind of diversion tomorrow where they won't have to come in. And we've done everything we could as far as getting witnesses, but we're at that point where we're going to be able to do Mr. Aguilar today, hopefully resolve the tape matter on Monday, and then finish our case, hopefully, next week.
Then I will tell the jury when we break today that we have run out of witnesses at this point, that there's a significant legal issue that the court needs to attend to, and that we'll reconvene with the jury hopefully Monday morning.
And we'll be in touch with Your Honor regarding these tapes and what happens with these.
Because I still have not received a redacted set of the
Right,
tapes.
well, we're going to make sure you get that. Hopefully, we'd like to give you a redacted set that's been enhanced. You have and it'll make it easier with all tapes. It is a lot more work than I thought doing those verbatim tapes, transcripts, rather. Very well.
All right. I'm sorry, Ms. Clark, do you have something that we need to do?
Yes, Your Honor. Mr. Douglas had given me a handwritten statement as to the stipulation that he wanted, and that was acceptable to me, but I had asked for a stipulation in response to that with respect to prints lifted from the defendant's Bronco by latent print investigator Finch.
Mr. Carpenter?
Mr. Douglas had asked that I stipulate to the lifting of latent prints from the location at Bundy, which I agreed to do, and I'm only asking that in response, the defense stipulate to the lifting of latent prints from the defendant's Bronco on June the 14th.
Well, the only problem, I have no problem with that, except that part of my examination today, Your Honor, I want to go into the Bundy crime scene, so that I expect to limit to that. This is our case, and this is what we choose to call it. I have no problem with the foundational stipulation, but we're going to object it beyond the scope of the examination. We're only limiting to Bundy as a relevant portion.
Are you going to be, excuse me, Ms. Clark, are you going to be calling Mr. Aguilar as one of your witnesses with regards to the fingerprints in the Bronco?
If we have to, we will. Let's waste some more time. Great idea. We have the witness on the witness stand. We all know he lifted prints from the defendant's Bronco. We all know that the latent print person was there on the 14th at 1:30, lifted the prints, compared them.
What do they say?
The prints on the Bronco? The
What's your
defendant's.
offer?
The defendant's prints.
That's hardly surprising.
I felt the same way, Your Honor. But it is important that all we're asking is that the defense stipulate that on June the 14th at between 1:30, between 1:30 and 3 o'clock, that latent print investigator Finch responded to the Bronco and dusted it for lifted latent prints from the door, the driver's side door. That's all we're asking.
I have no problem with that, as I indicated. The problem is, and you've said many times, the counsel knows that she can make
Well, she's asking you at this point, are you willing to stipulate to that while this witness is here?
I don't want to stipulate that, yes, Your Honor, but I still object to any testimony off the Bronco. I'm limiting my examination to Bundy. I think that's what's relevant.
Well, you're giving me an inconsistent answer here, Mr. Cochran. Are you willing to stipulate it to that with this witness here today?
Yes, sir.
All right, thank you. You're right, you are entitled to present your case, but since this guy's here, and it's a... Ms. Clark, you heard Mr. Cochran's response?
I did. May I have one more, Your Honor?
Sure.
Mr. Cochran correctly, he wants to stipulate to the foundational issue of the latent prints having been taken as represented in the report. I would ask that counsel stipulate to the information on this report as being true and accurate, which is a page labeled L99, as I have agreed to stipulate to similar pages for their witness today. And we will...
It would just help if we tried to do these stipulations beforehand, counsel. Let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, who will be presenting the next defense witness?
I will, Your Honor.
All right, Mr. Cochran.
Defense, the next call is Aguilar.
Raise your right hand, please. Do you solemnly swear that the testimony you may give in the class not being before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat on the witness stand and state your first and last name for the record.
Gilbert Aguilar, Gilbert, Aguilar.
Mr. Cochran.
Good morning, ladies and gentlemen. Good morning, Mr. Aguilar.
Good morning.
Sir, what is your occupation?
Yes, I'm a forensic print specialist employed by the Los Angeles Police Department, assigned to the Scientific Investigations Division with the latent print section.
And for how long have you been employed, Mr. Aguilar?
Employed with
By
the Los Angeles Police Department for over 17 years.
All right. And how long have you been employed in the latent print section of the LAPD SID lab?
For over 10 years.
And during that period of time, can you tell the jury or give the jury an idea of how many latent print crime scenes that investigations you've been involved in?
I've been to over 20,000 latent print crime scenes.
And have you had occasion to conduct a number of latent print comparisons during that time frame?
Yes.
And how many comparisons would you say you've made an estimate generally?
Oh, in excess of 150,000.
Why don't we tell the ladies and gentlemen of the jury what a latent print is?
Sure. A latent print is the reproduction of the friction skin left on an object when you touch it. It's usually invisible and must be made visible or developed using fingerprint powders, chemicals, or you could use the laser. I'm talking about the friction skin. I'm talking about skin that's found on the fingers, on the palms of your hands. It's also found on your toes and your soles of your feet. It's different than the other skin on your body where it has these ridges or these lines that flow across. Well, the unique thing about these ridges is that they don't just flow from one end to the other. They will flow and they will stop. At the point where they stop, we call those ridge endings. Another thing these ridges will do is they will flow and they will divide into two ridges. At the point where they divide, we call those bifurcations. Because everybody has these ridge endings and bifurcations throughout their entire friction skin, but it's where they are in relationship to each other that would make a fingerprint unique.
All right. And while we're about it, then tell us the difference between a known and a latent print.
Well, a known print would also be considered an ink print, where you actually have the individual there, you apply ink to the fingertips or to the palms of their hands, and you roll their fingerprints on a fingerprint card. You actually have the person there, and you're the one who took their fingerprints. A latent print is a print that's found at a crime scene. You don't know whose it is. You develop it, you bring it back, and it's unknown until you actually do a comparison to the inked fingerprint.
All right. And how long have you been a latent print comparison expert?
I've actually been a comparison expert for over 6 years.
And have you had occasion to testify within the courts of this county and the federal courts as an expert in this field?
Yes.
And how many times have you testified prior to today?
Over 400 times.
Now, would you tell the jury, sir, something about how prints are lifted generally?
Yes. Usually, when you go out to a crime scene, you're usually taking fingerprint powders. You have a silver and a black powder, depending on what type of surface you're going to use the powders on to look for the print. Usually what you'll do is you apply the powder to the surface using a brush that's similar to an artist's paintbrush. Just brush on the powder. The powder adheres to any moisture that's left behind when you touch an object. The powder forms the print, or it develops the print so that you're able to see it. Once you develop this print, the next step would be to lift it off the item. And the way that's done is you apply a tape that is similar to Scotch tape, but it's a special type of tape for latent prints. You lift the print off the object, you put it on the fingerprint lift card for permanent record.
All right, now in connection with this case, the Simpson case, would you tell the ladies and gentlemen of the jury what role you played in that regard, sir?
Yes, in this case, I did all of the comparison work. I compared all of the fingerprints that were found at the crime scene to known fingerprints or to inked fingerprint impressions.
And prior to, so you did the actual comparisons, is that correct?
Yes.
And as I understand it, in order for you to do the comparisons, somebody before you had to lift the prints, is that correct?
The latent prints, yes.
The latent prints. And who in this case, can you give us the names of the individuals who lifted the prints in this case?
Sure. Can I check my records, please?
Sure, please do. If you need those refresher recollections, it'll be fine.
Yes, the prints were developed and recovered from the Bundy location by a Miss Claiborne, C-L-A-I-B-O-R-N-E, and also a Miss Braggs, B-R-A-G-G-S, and also a Miss Udeshi, U-D-E-S-H-I, and a Miss Duke, D-U-K-E.
Very well, Your Honor. I think we have a stipulation regarding Mrs. Ford's foundation. Ask the clerk what the next defense exhibit is. I believe we'll save a little time if the court pleases.
Thank you.
The first stipulation is, it is hereby stipulated that on June 13th, 1994, technicians from the Scientific Investigation Division of the Los Angeles Police Department, namely Braggs, Duke, Udeshi, U-D-E-S-H-I, and Claiborne, obtained 17 identifiable lifts from the Bundy crime scene. And those latent prints are accurately reflected on Defense Exhibit 1322. Let me change one word, Your Honor. Let me go back and state that briefly. It's hereby stipulated that on June 13th, 1994, technicians from the Scientific Investigation Division of the Los Angeles Police Department, namely Braggs, Duke, Udeshi, and Claiborne, obtained 17 latent print lifts from the Bundy crime scene. Those latent prints are accurately reflected in Defense Exhibit number 1322. In addition, it's further stipulated that on or about 1:30 p.m. on June 14th, 1994, a latent print investigator by the name of Finch dusted the Ford Bronco for fingerprints and obtained 3 identifiable fingerprints from the driver's side outside door. That those prints were identified as Mr. Simpson's left index and right middle fingers. Simpson's Ford Bronco.
All right. Is
So
that
stipulated, counsel?
Yes.
All right.
All right, ladies and gentlemen, if you recollect, a stipulation is an agreement between the parties as to the facts of the case. You are to assume the facts in the stipulation are true for the purposes of this trial. Mr. Cochran.
Thank you, Your Honor. I'd like to approach the witness with 1322 and place it before him. I'm sure you have a copy. And I want you to place 1322 before you. It's a document entitled Los Angeles Police Department Scientific Investigation Division Latent Print Section. You ever seen this form before, sir?
Yes.
And would you tell the ladies and gentlemen of the jury what that form is?
Yes, this is a homicide investigation report. When somebody goes out to a scene of a homicide and latent prints are recovered, each latent print is listed where the latent print was recovered from. And for each number, for instance, this one had 17, so the first one would be 1 of 17, 2 of 17, and so on. in this form that we use just to document where each of the prints came from, so we could hand that evidence over, or hand this form over to the investigating officers.
All right, and so in connection with these 17
I'll be
prints
right
that were
back,
lifted
guys.
on or about
Behave.
June 13th, 1994,
Yes.
was there an elimination attempted regarding the defendant in this case, Mr. O.J. Simpson?
Yes.
And when was that first elimination?
The first elimination was done on June 13th, 1994.
And so that we're all clear, what does an elimination mean?
Elimination means that we compared all of the latent prints to that individual and eliminated that person. Means that person did not leave those fingerprints at it. None of the latent prints were recovered were that individual's.
All right, so that I'm clear, I want to make sure I'm clear with what you're saying, that with regard to any of the prints lifted from the Bundy crime scene, those prints were compared with Mr. Simpson's prints, and he did not make any of those prints. Is that what you're saying?
Yes.
And that determination was made on June 13th of 1994. Is that correct?
Yes.
Now, were you involved in the case at that point?
No.
When did you get involved in the case?
I got involved in the case in late July of 1994.
And once you got involved in the case, as a latent print comparison expert, did you have occasion to review the work of those who had been involved in eliminating Mr. Simpson's prints back on June 13th?
Yes.
And for the record, if you look at 1322, can you tell us the names of the individuals who eliminated Mr. Simpson's prints on June 13th, 1994?
Yes, one of the individuals was a Mr. Alvardo, A-L-V-A-R-D-O, and the other individual was Mr. Capati, C-A-P-T-I-A, I believe.
All right, and those are your colleagues, is that correct?
Yes.
And now, when you got involved in the case in July of 1994, did you have occasion to look at the 17 prints lifted from Bundy and compare those prints yourself with those of Mr. O.J. Simpson?
Yes.
And what did you find, if anything, in that regard?
That none of the latent prints are recovered from the crime scene were identified to Mr. Simpson.
All right, now, in connection, you have described for this jury and the court what a latent print is versus a known print. And with regard to the 17 prints that were lifted at Bundy, I would like for you now to take us through and let's talk about where those 17 prints were found in order of the report. Can you do that for us?
Yes.
And with regard to prints that are found, you'll then tell us whether they were able to be identified or non-identifiable or whatever. Is that correct?
Yes.
All right. Let's start. And do you have them in some kind of number or some kind of order?
Yes, I have the original latent prints, all 17 of them, that were recovered from the crime scene.
All right. And why don't you tell us where those prints were found?
Yes, the first print, number 1 of 17, the latent print was recovered from the inside of the front door frame at Bundy location.
You know, what I'd like to do is to mark this as, if I might interrupt the witness, I'm sorry, is number 1323. And while he's doing that, if the court pleases, and I'll show it to Mr. Darden, I'd like to put it on the Elmo if at all possible.
All right, the latent lift card?
Yeah, well, it's not really a lift, but no, this is a report. And before we get to the second page, I'm going to... I have now number 1323, which is a documented title, Eliminated Latents Package A. I'd like to put the witness, a little foundation, if I might. I want to place this before you again, Mr. Willard, and ask you to take a look at this document now, Defendant's 1323 for identification. Do you recognize that document?
Yes.
And what is that?
Yes, this was a document that was written to indicate another, just as the same as the 187 investigation report or the homicide investigation report, was to indicate where the lists were taken from, and also to indicate whether the print was identifiable, whether it was identified to an individual, or whether the print was non-identifiable, which means that it didn't have sufficient characteristics to positively identify it to anybody.
All right, so this is kind of a summary of the 17 prints we've been talking about.
Yes.
And this may help make it clear for our jury as to where these prints were recovered and that sort of thing. Is that correct?
Yes.
Okay. This is an LAPD form?
No, sir.
Who wrote this?
Mr. John Green, from the supervisor in my section, wrote that.
Okay, he's a supervisor in the LAPD.
Yes.
It's kind of a summary, is that correct?
Yes.
All right. I'm going to put this on first page 1, 2 page. I'm going to save some time while we're putting this up. Why don't you tell us, sir, where these lifts were found? You may proceed.
Okay, lift number 1 of 17 was found on the inside front door the door frame, and that print. Sorry, do you just want me to just indicate where they were found?
You can tell us where they were found and whether or not it was an identifiable print and whether or not it was identified to any particular individual.
Okay, and you also want the individual who was identified to?
Yes, you can do that.
Yes. Print number 1 of 17 was identified to Nicole Simpson.
And where was that found again?
It was found on the inside front door frame.
All right. And then what about prints 2, 3, and 4? Where were they located?
Yeah, 2, 3, and 4 were also located on the inside of the front door. 2 and 3 were actually on the door next to the door knob, and number 4 was also on the door frame, and neither one of those prints, or prints number 2, 3, and 4, were not identified to anybody as of yet.
Were they identifiable prints?
Yes.
In other words, you got enough to determine these are latent prints, is that correct?
Yes.
But you have not been able to, as they say in the parlance, make those prints to any particular person, is that correct?
Yes.
Now, with regard to the print, if you have a fingerprint, there are certain systems within the state of California and perhaps nationally that you can run a fingerprint through to try to determine whether or not it matches up with certain individuals. Is that correct?
Yes.
And with regard to palm prints, are you able to do that?
No.
All right. With regard to palm prints, in this case, did you compare these palm prints, number 2, 3, and 4, with Mr. Simpson, first of all?
Yes.
All right, and those were not Mr. Simpson's prints, were they?
That's correct.
And did you have occasion to compare those prints with any other individuals in this case?
Yes.
All right, and first of all, did you have any other known prints that you compared? These 3 latent prints we're talking about now, Your Honor, and that's on Defendants 1323, I believe?
Yes.
All right. Did you compare those 2, 3, and 4 with any other known prints in this particular case?
Yes.
Who was that?
It was, I compared them with over 58 individuals.
All right, and where'd you get these names for the 58 individuals?
I got them mostly from the investigating officers in this case.
In other words, what you tried to do was did you use the crime scene log?
Yes.
And did you go out and try to take and get the prints of everybody who you knew had been at the scene on or about the early morning hours of June 13th of 1994?
Yes, we tried to get everybody's fingerprints.
And altogether, there were some 58 names that you ran or checked?
Yes.
Okay. And I presume you at some point got the palm prints of each of these individuals, is that correct?
Yes.
All right. And you were able to compare the palm prints of these 58 individuals with items 2, 3, and 4, is that correct?
Yes.
Now, in addition to that, you've already told us that you compared these 3, 2, 3, and 4 with Mr. Simpson. Did you compare them with any other known prints of any of the victims in this case?
Yes, I compared them to the fingers, or I compared 2s, 3s, and 4 to the palm prints of the victims that we had.
All right, that would be Ms. Nicole Brown Simpson, Mr. Ronald Goldman.
Yes.
So if I'm counting correctly, you compared the 2, 3, and 4, the identifiable palm prints on the interior door of the residence at Bundy with some 61 individuals, is that correct?
Yes.
And were you able to identify any of those 61 individuals as having made the palm prints 2, 3, and 4 on 1323?
No.
Have you compared those palm prints with anyone else at this point?
No, I don't believe I have.
All right. So what we've done, you compared it with with Mr. Simpson and Ms. Brown Simpson and with Mr. Goldman, right?
Yes.
And then the 58 people who were in and about that scene and or were friends, is that correct, of Ms. Brown Simpson?
Yes.
And family. All right. Your Honor, I'd like to mark as next 1324, which is a 5-page document of these are individuals.
All right, 1324, this is the list of comparisons.
The total, I think it totals 58 plus the 3, Mr. Simpson, Ms. Brown Simpson, and Mr. Goldman.
All right, 1324.
I have no problem, and so that he knows the yellow copies these are the people from SID. May I approach, Your Honor?
You may.
Okay, 1324. I want to place this before you, and I'll put it on the Elmo afterwards. What is this document number 1324 that I placed before you?
Yes, this is a homicide worksheet. We fill out this form whenever we do a comparison to a homicide case. If we're comparing an individual's fingerprints and palm prints to the list, we will indicate the individual's name and any information that we have on that individual so that we know how many people and who we checked against those prints.
All right, and in this connection, you've already told us that you used the crime scene log. You took names off there, is that correct?
That was one of the way, yes.
And what other individuals did you check should be on that list?
I believe family of Nicole Brown and friends.
All right, so you and I'd like to continue on with the
Proceed.
Now, so that we get a flavor for some of the individuals who were checked, I noticed there's a Phil Van Adder. So you checked his palm prints against 2, 3, and 4.
Yes.
We went down this list. This first list here, 1324. Are these individuals that you received from crime scene log?
Yes.
I noticed that most of them have numbers afterwards. Are those LAPD numbers, Joe?
Yes, those are employee serial numbers.
So you checked and you tried to check the LAPD officers who had logged in on that particular date. Is that correct?
Yes.
Okay. As to the second sheet, did you check coroner's representatives and photographers who were also there that day?
Yes.
And so, and by the way, in this form where it says package, what does package A mean?
Yes, package A means that that's the first package that we got at the crime scene. Sometimes you may have more than one investigation to it. So you might have a scene, then you have to go print a vehicle, or you might have evidence to process in the lab. So every time that we do an investigation at different locations or different scenes, then we would give it a different package, A, B, C, and so on.
All right. And with regard to this second page of 1324, there's some highlighting of we've been pushed all the way up, of 4 individuals. And those people we talked about, your colleagues at Leighton Brent, Udeshi, Duke, Braggs, and Claiborne?
Yes.
All right. And they've been highlighted as individuals who work within the lab. So you checked them against the prints also, is that correct?
Yes.
All right. Third part of 1324. Again, you use a log and check police officers and anyone else at the scene. Is that correct?
Yes.
And the fourth page, finally. Fourth and fifth page. Fourth page is you've had occasion to check family members like Denise Brown. Is that correct?
Yes.
So Lewis Brown.
Yes.
Ray Resnick. Is that correct?
Yes.
All right. And lastly, the fifth page, apparently again, are other individuals from the crime scene log. Is that correct?
Yes.
Okay, now, so that we're clear with regard to then items 2, 3, and 4 of items 1323, you then checked all of the 58 individuals we've just seen cursory, and plus the other 3 we've added, 61 individuals, right?
Yes.
And those prints then are still outstanding. You don't know who those prints belong to, is that right?
They haven't been identified. That's correct.
All right. Now, let's continue on with what you found regarding the latent prints. Let's move on to print number 5, if you can. Let's put that back in there. All right. I think we're down to print number 5, and where was that recovered from, sir?
We're back on 1323.
1323. Yes, Your Honor.
Yes, print number 5 was recovered from the handrail next to the front door. That print is indicated it's non-identifiable. It lacks sufficient characteristics in that print to ever identify it to who left it. Even if you had their fingerprints and their palm prints, there's not enough there to identify that print.
All right, so we will, based upon it being non-identifiable, we'll never know whose print that is. Is that correct?
That's correct.
All right. Now let's move on to print lift number 6.
Yes, that number 6 was recovered from the handrail to the front entrance in the stairwell.
All right, the handrail from the front entrance in the stairwell at the Bundy location.
Yes.
Now, at some point, you had occasion to go out to the Bundy location. Is that correct?
Yes.
When was that?
Went out, I believe it was twice in February of 1995.
All right, twice this year. Is that correct?
Yes.
And did you, at that point, try to look and see these various locations where these prints were taken?
Yes.
All right. But this one, so we're clear about this, is a left thumb print. Is that correct?
Yes.
And it was collected from the handrail, middle attached to the front entrance stairwell. Is that correct?
Yes.
Where is that? Down near the front gate? Do you remember?
Have to check the...
All right, what are you checking?
Yes, I'm checking the original latent prints that were recovered from the crime scene that would indicate a photograph, or not a photograph, but a drawing of where it was. It might help me refresh my memory of where it came from.
Please do that.
Yes, number 6 did come from the rail close to the front gate.
All right, and was that an identifiable print?
Yes.
And do you know whose print that was?
Yes.
Whose print was that?
Yes, it's the left thumbprint of a photographer named Goodwin, Mr. Goodwin, Goodwin.
So that's one of the photographers who was at the scene. Did you see that photographer's name on the crime line?
Yes.
All right. And I noticed you mentioned by left thumb on this point, where it says 6 left thumb APHIS. What is APHIS?
Yes, APHIS is, what it means is the Automated Fingerprint Identification System. It's the fingerprint computer that we use to try to search fingerprints, search them through our database.
All right. So you didn't have to use APHIS on this, I presume, because you knew it was one of the people that you checked, one of the 58 was Goodwin. Is that correct?
Right. It was indicated that the print was good enough for APHIS, but once it was identified, there was no need to process it further.
All right, I understand. Let's move on to number 7. Now, these are all outside the house, as I understand. Is that correct? These prints
Yes,
we're talking about?
number 7 would be, not all the rest of them are outside the house, some are inside.
Well, let's see what I'd reference to. I'm sorry. As I understand it, 5, 6, 7, 8, 9, and 10 are outside the house.
Yes.
Right? Okay. Then let's talk about number 7.
Yes, number 7 was recovered from the top of the gate post, or a small gate outside the front door leading to the rear of the location.
All right. And was that an identifiable print?
No, it was non-identifiable.
All right. So you had a latent print, but you cannot with specificity make that to any individual. Is that correct?
That's correct.
All right. All right. Let's move on to number 8. It's another palm print. Where was that recovered?
Yes, number 8 was recovered from the outside of the stairwell, the handrail, north side of location.
Okay. And the location being the Bundy residence. Is that correct?
Yes.
Mr. Cole Brown Simpson?
I'm sorry.
Of Mr. Cole Brown Simpson?
Yes.
All right. And was that an identifiable print?
Number 8?
Yes.
Yes.
So that was a print that was identifiable. Is that correct?
Yes.
Were you able to make that print to any individual?
No.
So that's a print that is outstanding, if I can use that word at this point. You've not been able to make that to any individual, although it had enough characteristics for you to call it an identifiable print. Is that correct?
Yes.
And of course, that print was compared to Mr. Simpson's, was not Mr. Simpson's, right?
It was not made to Mr. Simpson, yes.
All right. And at this point, this palm print is still outstanding. Is that correct?
We still don't know who it belongs to, that's correct.
Okay, and because it's a palm print, we're not able to use the APHIS system or the other systems we've talked about, right?
Right.
All right. Let's move on to print number 9, sir. Where was that located?
Yes, print number 9 was located from the outside stairwell handrail, the north side of the house, pretty close to where number 8 was.
All right. And was that an identifiable print?
No, that print is also non-identifiable.
And again, that means that you couldn't make that to anyone.
That's correct.
All right, let's move to number 10.
Yes, number 10 was recovered from the outside gated entrance, the door bar, the gate in the front of the location.
The gate at the front part of this location, this residence, we've all seen that. It's outside that?
Yes.
Toward the Bundy side of the street?
Yes.
All right. And tell us again where that was, this print.
It was from the outside gated entrance, the door bar.
All right. And was this an identifiable print?
Yes.
And in that connection, then, this print was lifted. And what was this print? What was lifted, if anything?
Yes, a latent print was recovered from that gate that consisted of 2 fingers.
All right. Which fingers were they?
Can I check the latent lifts?
Sure, if you can.
Yes, it was identified to the left index and the left middle finger.
All right. By the way, you were referring to a latent print card. Can you hold one of those up, and perhaps we can show the jury what that looks like, or what those latent print looks like? May I approach your arm? I want to pass it around.
Yes, pass.
All right. Well, let me approach it. Tell us what that is.
Yes, this is the latent print card, or the left card, that was recovered from the Bundy location. This one here would be indicated 10 of 17. This is the one that was recovered from the front gate entrance.
All right, and that's a lift. That's an actual lift from that front gate area?
Yes, this is the actual latent print itself that was removed.
You'd like to have this back, would you?
Yes.
Okay. I won't mark it then. May I just pass?
So what we'll do is we'll place a photocopy in evidence.
All right, do you want to mark it then, Your Honor?
Yes, let's mark that as 1325.
Okay, we'll make 1325. We'll make it a copy of this, Your Honor. Where do you want to start?
Sure, number 1.
Now, so what...
Excuse me, Mr. Carpenter. When we pass something to the jury, it's my preference that we not take any further testimony so that they have their undivided attention looking at the item.
Sure, Your Honor.
All right, the records reflect that the print card regarding this particular two fingers lift has been returned. And if you could, Mr. Cochran, would you give it to Mrs. Robertson, and we'll have one of the law clerks make a photocopy back and front. And we'll substitute that as 1325.
I'm doing that right now. Thank you, Your Honor. I think we were talking about lift number 10. Is that correct, sir?
Yes.
And this was the one out by the outside gated entrance door bar. And with regard to this latent print, did you have to run that print through the APHIS system or any other system at all?
It was indicated that it was good enough for the APHIS system.
All right. And were you able to make this print to any particular individual?
Yes.
And who was that individual?
Yes, it was Detective Ron Phillips.
Was that one of the detectives in this case?
Yes.
All right. That was his print. Is that correct?
Yes.
All right. Let's then shift our attention to item number 11. You tell the jury where that item was recovered.
Yes, item 11 was inside of the Bundy location. It was recovered from the outside bathroom door that's between the kitchen area and the living room. It was, that print was identified.
Oh,
It was identifiable and it was identified.
Okay, it was identified, identifiable, and identified. And what was that print of? Was it a finger or a palm or what?
Yes, it's a finger.
Which finger was it?
It's the right index finger
And who was this print identified to?
to a Miss Faye Resnick.
Now, are you able to date prints as to when somebody made a particular print of the location?
And when somebody
As
left the print or when somebody
Yeah.
developed it?
No, as to when the print was left.
No.
All right. All right, now let's shift our attention to item number 12 that was collected.
Yes, number 12 was recovered from a pack of Marlboro Lights cigarette that was in the master bedroom or bathroom, the back of the toilet.
All right, you think that might be a typo there when it says bedroom?
Yes, it might have been.
All right. At any rate, was this an identifiable print?
Yes, it was identifiable and it was identified
And who was it identified to?
to the victim, Nicole Brown.
All right, and then with regard to, and we'll turn to the second page now, Mr. Harris, of 1323. Tell us about prints 13, 14, and 15. I believe they're all collected at the same location.
Yes, prints 13, 14, and 15, all three of them came from a white Ferrari vehicle that was in the back of the location.
All right, and were these 13 and 14? I see an AFIS, AFIS after that. Were those prints that were found on the Ferrari that are identifiable run through any systems?
Yes,
Describe what happened in that connection, sir.
yes, those prints, number 13 and 14, are both fingers. So we were able to put those two prints into the APHIS system, or the Automated Fingerprint Identification System of the Los Angeles Police Department, to see that if it would give us a possible match. That was unsuccessful. We did not get a match. So once that happened, we ran it through the Department of Justice fingerprint computer, and even with doing that, we still did not get a match. And we also went as far as running it through the WIN, or the Western Identification Network, which is a part of the western states that are hooked up to each other, that were able to access some of these computer systems. And we ran it through those systems, and they're still, the prints are still, have not been identified.
And these systems, these computer systems that you're talking about, do you have any idea of how many prints or the latent print is compared to when they run through the WIN system or the APHIS system?
Well, the APHIS system, the prints would be run through our entire database, and we have over 2 million fingerprint cards at the Los Angeles Police Department. When run it through the Department of Justice or through Sacramento, their computer system, it runs their entire database, which is, I believe, over 10 million fingerprint cards through there. Then the WIN program, I'm not too sure how many actual fingerprint cards are in the database for each individual location.
Guess we can say a lot, though, right?
Yes, more than Sacramento's would be.
Okay. But at any rate, it was run through the APHIS system and the WIN system, and you're not able to make these two fingerprints found on the Ferrari to any individual known at this point. Is that correct?
Yes.
All right. Now, we've already covered that with regard to a palm print, you're more limited. Is that correct?
Yes.
But with regard to the palm print that was found on the Ferrari, would I be correct in assuming that you compare that palm print to the 58 individuals who were on the log and or family friends, plus Mr. Simpson, Ms. Simpson, and Mr. Goldman? Is that correct?
Yes.
And though that palm print didn't come back to any of those individuals either, right?
Right.
All right. And shifting our attention lastly then to items 16, prints 16 and 17, where were they lifted from, sir?
Yes, both of those prints were lifted from a black Cherokee Jeep that was, both of them came from the outside passenger side rear fender.
All right. And were there identifiable prints lifted from this black Cherokee Jeep?
Yes, both of them were also palm prints.
And were you able to identify any individual with regard to these two identifiable prints?
No.
And again, they were palm prints, so you couldn't run them through the system, but you ran them out through all the individuals you mentioned before.
Yes.
All right, and they did not match up with anyone connected with this case, at least at this point. Is that right?
Yes.
Now, so that we're clear, to summarize, we had 17 lifts. Is that correct?
Yes.
17 prints were lifted, and of those 17, as I understand and keeping track, 14 of those were identifiable. Is that correct?
Yes.
And of the 14 that were identifiable, 5 were actually identified. Isn't that correct?
Yes.
Okay, so that leaves 9 that were identifiable but have not been identified, that are still out there. We don't know who made those prints, right?
Right.
Is that correct?
Yes.
Now, you last worked on this case when, sir? With regard to it, any comparisons or identifications?
The last time I did a comparison?
Yes.
I'd have to check my records.
Just approximately. I can ask you another question to
Okay.
save some time. Do you have the answer now?
Yes, I believe that the last time would have been February 7th, 1995.
Okay, so to summarize, if we could, and you can check your records if you need to, the prints that were identifiable but not identified to any individual are numbers 2, 3, 4, 8, 13, 14, 15, 16, and 17. Is that correct?
Yes.
So we saw on 1323. Is that correct, sir?
Yes.
Now, with regard to your testimony here, when's the first time you ever met me?
I believe this morning.
First time we ever talked, is that correct?
Yes.
All right. And I want to ask you a couple other questions. With regard to this concept of fingerprints, are you able to get fingerprints from inside of a glove, depending upon the glove?
Yeah, it would depend on what type of glove it was that.
All right. Some gloves you can get fingerprints from, and some others you can't, depending upon the type. Is that what you're saying?
Right, if it's a latex or a vinyl glove, then we'll attempt to get a latent print off of it. It is possible to get a print.
Did you attempt to get any prints off any gloves in connection with this case?
No.
Now, just 1 second, Your Honor.
Sir.
Do you know whether or not, and looking, and I can put the chart back up, of the 58 plus family members, do you know whether or not the children's prints, you obtained the known prints of the Simpson minor children, Justin and Sidney Simpson?
Oh, they do not.
Could you rule out any of the prints remaining by virtue of the size of the prints? That is, the adult prints or whatever?
I would have to know the size of the children.
All right, so you don't know at this point. Is that correct?
No.
All right. Now, with regard to your work and your examination here, you told us that at some point you had a reference or a known print from Nicole Brown Simpson, from Ron Goldman, and from O.J. Simpson. Is that correct?
Yes.
And Mr. O.J. Simpson's prints were obtained on June 13th. Isn't that correct?
Yes.
And that enabled them to eliminate him that same day. Isn't that correct? Because they had his prints as of the 13th.
Yes.
With regard to Ms. Nicole Brown Simpson, did you have both of her palm prints?
No.
And with regard to that, were you relying upon the coroner's office?
The coroner's office are the one that took the palm prints.
All right. Whomever in the coroner's office took the palm prints? Is that right?
Yes.
And in that connection, what were you working with? What did you receive from either the coroner's office or their representative with regard to the reference prints of Ms. Nicole Brown Simpson?
Yes, we received the impressions or the fingerprints of all 10 fingers and the impressions or the palm prints of the right palm twice.
In other words, they took all 10 fingers, but they took the right palm twice, and you never had the left palm. Is that right?
That's correct.
But you did have all 10 fingers. Is that right?
Yes.
May I have just a second, Your Honor? Did you, in the course of the investigation in this case, did you have occasion to talk with the investigating officers in this case at all?
Yes.
And from them, I presume you were able to obtain the logs of people who've been at the crime scene, that sort of thing?
Yes.
And through them, I presume you were able to get the prints and palm prints of friends of Miss Nicole Brown Simpson, is that correct?
Yes.
At any point when you knew that you had some 9 prints that you couldn't match up, identifiable prints we couldn't match up, did anyone ever take either the fingerprints or the palm prints of the minor children at all?
Not to my knowledge.
Did you ever request that?
I requested to the parents of Nicole Brown, when I fingerprinted them, when they came to the location to get fingerprinted, I indicated to them that we would like to have the fingerprints of the children.
Okay, now what they said back to you, you made that statement to them?
Yes.
All right. Did you ever get those prints at all?
No, sir.
All right. If I want you to assume hypothetically the children were 5 and 8 years of age. Do you have that in mind?
Yes.
And would you, if you knew the children were that age and they're normal, healthy children, would you have an idea of the size of those children's hands? A boy 5 and a girl 8?
Again, it would depend on how big they were, not just how old they are.
Right. Assume they're normal, healthy 5-year-olds and 8-year-olds. You know what that means? That may be a little vague, yes, I'll agree. Assume they're normal-sized children, for 5 years old and 8 years old. That's probably still vague, isn't it?
Yep.
All right, let me see this. At no point did you ever get the children's fingerprints, did you?
That's correct.
All right. And in regard to these prints that are identifiable but not identified or made to any particular individual, do you know whether any of those prints were small enough to be children's prints?
Oral.
Yes.
Do you know that for a fact?
By looking at it and determining the size of the ridges and how far they are apart from each other, there is at least one print in there that could belong to a child as young as 3 years old to maybe even a young adult.
All right, so that's one of the 9?
Yes.
All right. So of the other 8, I presume from my question then, the other 8 would not be, in your opinion, made by a child.
Let me re-examine the list.
Sure.
The list.
May I approach? Not that I know what I'm looking at.
Well, perhaps we ought to take our break now, and let Mr. Aguilar look at it over the lunch hour, and then we
But
can...
and I'm finished at this point, unless, may I have a second?
No, we need to finish right, we need to quit right now.
So now you've now looked through all of the 9 prints that have not been identified to any individuals, is that correct?
Yes.
And you've taken one card out, is that correct?
Yes.
And this one card is the one that you're referring to that could have been made by a youngster or a child, is that correct?
Yes.
All right. The other 8 then, I presume, could have been made by adults, is that correct?
The ones that are identifiable. The
Yeah.
other ones that are non-identifiable, I couldn't tell.
Right. Now I'm talking about the identifiable ones. I'm talking about the 9 identifiable ones, right?
That's correct.
And your testimony is that of those 8, the 8 of those would be from adults, right?
Or a big child.
Okay. Big child, big child or adult, right?
Right.
Okay. Very good.
And I don't think we've identified for the record purposes which one of those is that Mr. Aguilar has indicated is possibly a young child.
Sure, Your Honor.
Which print of the
Why
17
don't
is that?
why don't I do that, Your Honor? Of the 9, this is one, Your Honor, and it's number, DR number? It's number 4 of 17. It was item number 4 of 17, Your Honor, and it was recovered from inside the front door frame.
All right, we need to take a recess at this point.
All right, very well, Your Honor.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember all my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1 o'clock. All parties are again present. Deputy McNair, let's have the jurors, please. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. All right, Mr. Aguilar, would you resume the witness stand, please? All right, the record should reflect that Mr. Gilbert Aguilar is on the witness stand, currently under direct examination by Mr. Cochran. Good afternoon, Mr. Aguilar.
Good afternoon.
Mr. Aguilar, sir, you're reminded you were still under oath. And Mr. Cochran, do you have some additional questions?
No, Your Honor.
All right, thank you.
I just wanted to skip the court report.
Mr. Darden.
Yes, thank you. Good afternoon. Mr. Aguilar, you wouldn't expect a person wearing a pair of leather gloves to leave fingerprints at a location.
Overruled.
No.
How many prints have you said that you've lifted and compared during your career?
Oh, over 125, maybe 150,000.
Now, are you aware that in this case we are somewhat concerned with a pair of bloody leather gloves?
Overruled.
Yes.
And are you also aware that those gloves have a cashmere lining inside?
Yes.
Now, we don't always leave fingerprints on every surface we touch, do we?
Very rarely.
And you can't always lift a fingerprint from each and every kind of surface, can you?
No.
Can you lift a fingerprint off cashmere?
I've never heard of anybody that has. You could try, but I've never heard of any success.
Now, when you're dealing with a situation where you have a pair of leather gloves that are bloody, you as an analyst, you're in a catch-22 situation of sorts, aren't you?
So thanks, vague.
Okay. Well, when you have a pair of bloody leather gloves,
Overruled.
you can imagine, I take it, circumstances where you might want to try and lift a fingerprint off those leather gloves, correct?
Yes.
Okay. And at the same time, you might also want to do some serological analysis, blood analysis, correct?
Yes.
Assuming that you have a fingerprint on a pair of leather gloves, and the gloves are also bloody, can you do both the serological analysis and lift a fingerprint?
If you have a latent print that's there,
Yeah.
you'd have to take the blood before you try to process it for fingerprints, because the chemicals that we would use to process it for any latent prints would have a good tendency, or they would destroy any evidential value of the blood.
And any chemical used to remove the blood could also destroy the underlying latent fingerprint. Is that correct?
Overruled.
Is that correct?
Yes, even if you don't use chemicals, you're just wiping it off will destroy print.
What are the chances of lifting a latent print off of a pair of leather gloves?
Sustained.
Well, have you ever lifted a fingerprint off a pair of leather gloves?
Never been able to develop an identifiable print
You've
Talk
never,
about leather or on
off a leather glove.
you've never been able to develop an identifiable fingerprint from a leather glove?
Overruled. I interrupted and asked a question.
May I re-ask the question?
Please.
That's correct.
Okay, you've never been able to lift an identifiable fingerprint from a leather glove?
That's correct.
And there are other surfaces that we don't commonly leave fingerprints on when we touch those surfaces. Is that correct?
Yes.
And those include stucco?
Stucco, yes.
Okay. You've been out to Bundy, is that correct?
Yes.
Is there stucco on the walls on the walkway near the front door? Outside the front door, rather?
I believe I did look at the surface of the walls on the residence, and it was very rough. I don't remember if it was stucco or not, but determined that nothing could have been done.
Okay. How about concrete?
Concrete is very difficult.
And why is that?
Well, concrete is a porous surface, and it's not very smooth. Even if it's a real smooth surface, it's going to absorb the print in there almost immediately, and you're not going to be able to develop a print.
How about cloth?
But cloth is almost impossible. You could try to develop prints off of it. If you're unable to see the print, there are chemicals you could try to use, but the success rate, in fact, I've never even tried to get a print off of a cloth. I've read about it, and I haven't read of any success that you're unable to see the print and develop it.
Okay. How about flesh? If I were to touch your hand, would I leave a fingerprint on your hand?
Depending on what part of the hand.
Okay, on the back of your hand.
The back of my hand, it's very unlikely. The skin, a human skin, it's very hard to get prints off of. I've tried to get prints off of over 30 homicide victims, and I was unsuccessful in different operations to try it. Different chemicals, different procedures. I've been unsuccessful. There are a couple of cases that I do know about where somebody did actually lift a latent print from a homicide victim.
And you can't date a fingerprint, can you?
No.
No, but I'm gonna try. Does this fingerprint have red flags? I'll date it.
Today was the first time that you met Mr. Cochran?
I believe so.
Okay. But you have met Mr. Douglas, haven't you?
Yes.
Okay. On how many different occasions have you met Mr. Douglas?
Met him at least 2 other times.
And you spoke with him regarding your testimony?
Yes,
You spoke to him regarding your analysis?
yes,
And when you spoke to Mr. Douglas, was he accompanied by 2 other gentlemen?
at least 2 other, yes.
Okay. Do you recall the names of those 2 gentlemen?
I know that one of them was Deputy District Attorney Alan Yogelson,
Okay.
and the other one, I don't remember his name, but I believe he was a defense investigator.
Okay. Do you recall meeting with a man by the name of Rago, Mr. Rago?
Larry Rago, yes.
And he is a criminalist for the defense?
Yes, he did indicate he was for the defense.
You told us that you eliminated the defendant here from the identifiable prints that you were able to analyze. Is that correct?
Yes,
Did you also eliminate Detective Van Adder from the identifiable prints?
yes,
Did you eliminate Detective Furman from the identifiable prints?
yes,
And did you eliminate, rather, Detective Lang from the identifiable prints?
yes,
Now, you told us about prints numbered 5, 7, and 9. Number 5 being a print lifted from the handrail next to the front door. Is that correct?
yes.
Was that print left by the defendant?
I don't know.
Could have been, huh?
It's unidentified.
Rephrase the question.
Okay. You can't tell us that that print was not left by the defendant. Is that correct?
That's correct.
And with regard to print number 7, a latent print lifted from the top of the gate post. By the way, is that the front gate?
No, it's a small post, excuse me, between the front door of the residence going towards the back gate. It's in between those 2 locations.
You can't tell us that the defendant didn't leave that print. Is that correct?
Rephrase the question.
Can you tell us whether or not the defendant left that print?
No,
You can't tell us that he didn't leave the print. Is that correct?
correct.
And print number 9, that is a print located outside. Is that on a railing on the stairwell on the north side of the house?
Yes, it indicates it's outside stairwell, north side of house.
You can't tell us that the defendant didn't leave that print, can you?
Rephrase the question.
Can you tell us whether or not the defendant left that print?
No,
You can't tell us that he didn't leave that print, can you?
Different print.
correct.
And you also told us about print numbers 2 and 3. Now, both of those prints located near the doorknob on the front door inside the house.
Yes,
And did you describe those prints as identifiable prints?
yes,
You couldn't match those prints to anyone in particular?
that's correct.
Now, this is a residence, correct?
Yes,
And it's not unusual or uncommon that after printing the residence that you're unable to match a fingerprint located near the doorknob on the door, is it?
I'm sorry, can you repeat the question?
Well, these 2 prints that are located near the doorknob on the front door, that's not uncommon. That is, it's not uncommon that you are unable to match those prints to someone in particular, is it?
You can answer the question.
Yes, that's correct.
And that's because people come and go through that doorway, one would assume. Is that correct?
Yes,
Strangers come, strangers go.
yes,
And each time that someone grabs the doorknob, for instance, fingerprints that may have been left there by others are obliterated. Is that right?
It's cross-examination.
Is that right?
yes. Not only will it destroy or tend to destroy any prints that are left behind, but you can leave a print over a print, and you can not identify either print.
Okay. And with regard to print numbers 2 and 3, you can't tell us when those prints were left on the door, can you?
No,
Now, you told us that you identified one of Detective Phillips' fingerprints at the scene.
yes,
One of the things that you do as an analyst is you attempt to eliminate known individuals from having left fingerprints at crime scenes. Is that correct?
yes,
Okay, so what you do is you go out somewhere, somehow, and you obtain known exemplars of known individuals' fingerprints, right?
yes,
Okay. It's not uncommon for police officers to leave their prints at a scene, is it?
no,
And one of the things that you do as an expert, a fingerprint comparison expert, is you look at the prints left at the scene, compare those to the officers so that you can eliminate the officers or at least identify who left prints at a scene, right?
that's correct.
Nothing unusual about that.
None at all.
You told us about print number 8, which was a palm print on the railing.
Yes,
No.
And I think you
No,
also told
after
us that you-
Christmas.
received from the coroner only one of Nicole Brown's palm prints. Is that right?
I received the right palm print twice, 2 sets of right palm prints.
Okay. You did not receive her left palm print.
Hold on, let's count.
That's correct.
Let's see.
Now, the unidentifiable palm print on the railing,
I'm
number
gonna
8.
count exactly. Hold on.
Can you tell us whether or not Nicole Brown left that palm print?
You mean the print that was identified but was not identified to anybody?
Okay. Yes.
The only
No,
thing
you-
I
I
can't
cannot tell
count
you
is
who left that
sidebars
print.
that we
It could've
fast
been
forward through.
You can't exclude Nicole
So
Brown.
that's
No.
And that's
that's
because you don't have her left palm print card. Is that correct?
That's correct.
Okay. And that is an identifiable print, right?
Yes.
With regard to that particular print, number 8, the identifiable palm print, number 8, can you tell us whether or not that palm print is consistent in size and shape, as is Nicole Brown's right palm print?
Can you tell something like that?
Yes, I examined it to the right palm print. The right palm print that I had to eliminate that it wasn't the right palm. So I examined it, and doing that examination, noticed that the ridge detail, the thickness, how far apart they were, the whole shape, were consistent with the right palm. But it was not the right palm.
The right hand and the left hand on any individual both have different fingerprints, right?
Everything is different,
Okay. And the palm prints on each hand are also different.
completely.
You also talked about the Ferrari. Is that right?
Yes,
And those were print cards 13, 14, and 15?
yes.
Are you aware that the Ferrari was locked in the garage when the police discovered the bodies?
okay. We have 1,249 minutes left until the
Print card number
ferment tapes.
13.
Kind of. I don't know exactly when they start.
No, there was
Okay.
testimony about that.
So
Item number 13, that is where was that print located on the Ferrari?
Yes, it was located on
We
the
s-
hood area.
we do
on the
it at
driver's side of the hood
1.25
area,
speed.
Towards the front of it, so it'd be almost right where the headlight is on the driver's side of the vehicle.
And that is an identifiable fingerprint?
Yes,
Were you able to match that print to Miss Brown's mechanic?
Sustained.
we will get to it.
Did you attempt to match that print? to
No,
someone
I'm still trying to figure it out.
You understood to be Miss Brown's mechanic.
8 days from now,
Sustained.
Well, you have a list of
Maybe.
58 names, right?
we
yes,
we
You don't know
fast
who
forward
everyone on
through,
that list of 58 names is that correct?
not everyone.
you know, sidebars and things like
You don't
that.
know
But
whether or not that print, number 13, was left by Miss Brown's mechanic, correct?
right after Christmas, it looks
That's
like.
correct.
And item number 14, that is where on the Ferrari is that print located?
Yes, it was located on the driver's side front window, the window on the door on the driver's side of the vehicle.
Can you tell whether
Happy
or not
Friday,
that print was
Kelly.
left by a right hand or a left hand?
Can I take a look at the lift?
Mrs. Robertson, did we get a photocopy of that other print card?
Okay. Number 14. There's just a single print, and I'm unable to determine whether it's a right hand or the left hand.
You don't know where Miss Brown last purchased gasoline, do you?
No,
You don't know if some homeless person washed the windshield on her car, do you?
Sustained. Sustained.
At any event, you can't match that fingerprint to anyone in particular, is that right?
correct.
And card number 15, print number 15, where is that print? Where on the Ferrari is it located?
Yes, this is on the outside of the driver's door, just below the window.
Who left that print?
I don't know.
Oh. Now, this was a Ferrari, is that right?
Yes,
And what color was it?
white.
You don't know whether or not some curious person touched the car while looking inside, do you?
Sustained.
Would you agree that with regard to
Would that be
each of the
double
prints listed
jeopardy
from the garage,
if they tried to try him again? After you hear her affirming, you might not. You might understand why they didn't bother.
sorry. Let's strike that. Let's go to cards number 16 and 17. These relate to the Jeep Cherokee, is that correct?
Yes.
And that's Nicole Brown's Jeep Cherokee.
I don't know who owned it.
Okay. Is it your understanding that the Cherokee was parked in the driveway at the rear of the condo?
Yes.
You don't know where that Cherokee had been that day, is that correct?
That's correct.
You don't know if Nicole Brown drove it to the recital?
No, I don't.
You don't know who, if anyone other than the murderer, touched that vehicle, is that correct?
Sustain.
In any event, you lifted 2 prints from the Jeep Cherokee, is that correct?
Miss Duke lifted 2 prints.
Okay. And were either of those 2 prints located near the door handles to the vehicle?
No, they were on the outside, the passenger side of the vehicle, rear fender.
The rear fender?
The rear.
You've already told us that you can't date a fingerprint, correct?
That's correct.
How long can they last on the surface?
A latent print could last, depending on the circumstances, could last as little as a few seconds to a year, maybe more.
Now, when someone frequents a residence, it isn't uncommon to find their fingerprints in different areas of that residence. Is that correct?
It is scientifically proven that children's fingerprints last until you actually clean them.
You do find their fingerprints in different areas, yes.
Did you find any prints in this case, any prints belonging to the defendant that would suggest to you that he frequented Nicole Brown's condominium?
Sustain. Rephrase the question.
Well, did you find the defendant's fingerprint near any other bathroom areas inside the condominium?
But rephrase the question.
Okay, prints were lifted from one of the bathrooms, is that correct?
From the outside door, yes.
Okay, you didn't find the defendant's fingerprint there, correct?
His fingerprints were not there.
You didn't find the defendant's fingerprint on the interior doorknob to the front door, is that correct?
His fingerprints were not there, that's correct.
Now, you told us that there were other individuals whose fingerprints you didn't have to compare to the prints left at the scene, is that correct?
Yes,
Okay, that would include Sidney and Justin Simpson?
yes.
You weren't allowed to have those?
You requested those?
Yes, I requested them, but I never received them.
Okay. We've all probably seen persons have their fingerprints taken and placed on an exemplar card on television. Is that basically how it goes? You roll your fingers in ink, and then they're rolled onto a card?
Yes, you apply a thin layer of printer's ink to the fingerprints, you roll it across, and then you get it to the white fingerprint card, and you just roll it again, and you get a permanent record of the ink print.
Did you compare, let's strike that. You told us that you compared Denise Brown's fingerprint to the latent prints lifted at the scene. Is that correct?
Yes,
Are you aware that she has another sister named Tanya?
yes.
Did you compare hers?
I don't remember if I did or not.
Are you aware that she has another sister named Dominique?
No, I don't know how many sisters she has. I know she had at least one.
And did you compare Dominique Brown's known exemplar to the latent prints at the scene?
I'd have to check my records.
While he's
No, I only, the only sister that I compared was a Denise.
Now, the document you're looking at, that document was marked by Mr. Cochran. Is that it?
It was one of them, I believe.
And that is a page from that list of 58 individuals whose prints you compared to the latent prints at the scene. Is that right?
Yes.
Now, when you met with the defense expert, Mr. Rago, did he ask you to obtain Dominique and Tanya Brown's fingerprints and compare them to the,
Speaking objection, sustained.
did you compare Jason Simpson's print?
No.
Did you compare Nicole Brown's babysitter's prints?
Sustained.
Do you know whether or not Nicole Brown had a babysitter?
Overruled.
No.
You know whether or not she had a maid?
No.
You know whether or not she had an Avon lady?
No.
Overruled.
How about a gardener or a groundskeeper?
Not aware.
You didn't compare the prints of any of those individuals or any individuals fitting those categories to the prints left at the scene. Is that correct?
That's correct.
Yeah. Is it uncommon to find fingerprints on areas or any areas that are accessible to the public?
Vague.
Okay, well, let's take a car, for instance. You have a car, right?
Yes.
You drive the car places and you park it, right?
Yes.
You park it on the street?
Yes.
Okay, it's accessible to the public?
Yes.
You are not able to know. There's no way for us to know what evidence was planted or if it was planted. And I say that meaning evidence could have been planted.
Yes.
It wouldn't be uncommon. It wouldn't be uncommon to find fingerprints on a vehicle that has been parked out in public, right?
That's correct.
And it wouldn't be uncommon to find prints on that vehicle that could not be matched to any known individual. Is that correct?
That's correct.
Now, by your testimony today, one strike there. Thank you, sir.
Mr. Cochran?
Just some questions, Your Honor. Thank you. Jack, well, all right, you work for the Los Angeles Police Department, is that correct?
Yes, sir.
You don't work for Mr. O.J. Simpson, do you?
No, sir.
And you were getting your direction, sir, were you not, from the investigating officers, in this case, the prosecution, isn't that correct?
I'm sorry.
You were getting your information from the investigating officers in this case, Lang, Van Adder, Berman, Phillips. Isn't that correct?
On who to compare the prints to?
Yes.
Yes.
Isn't that correct?
Yes.
You never talked to Mr. Simpson, did you? About
No,
that?
sir.
All right. Your job is working for the prosecution, isn't that correct?
No, sir.
Your job is working for the Los Angeles Police Department?
Yes, sir.
All right. And you were called by the defense in this case, isn't that correct?
Yes, sir.
You were called by them, were you?
No, sir.
All right. And you heard all the nice questions that Mr. Darden asked you. And despite all those...
Counsel, you don't need to refer.
I said nice, but okay, I was right. You heard the questions that Mr. Darden asked you, right?
Yes.
You don't know anything about any mechanic, do you, sir?
No, I indicated I didn't know if they had one or not.
Or a gardener or anything like that, do you?
No, I do not.
All right. What you came here to tell us, isn't it correct, sir, that of the... I'm asking... I haven't finished the question.
Finish the question.
What you came here to tell us, isn't it true, that there were 17 lifts lifted from Bundy. Of those 17 lifts, there are 9 lifts that were identifiable where you can't tell us who made those prints. Isn't that correct?
Yes.
And further, in addition to that, Mr. O.J. Simpson was excluded from all the lifts taken as early as June 13th, 1994. Isn't that correct?
Objection.
Sustained.
Mr. O.J. Simpson was excluded from the identifiable prints as early as June 13th. Isn't that correct?
Yes.
And then you further confirmed that and excluded Mr. O.J. Simpson in July of 1994. Isn't that correct?
Yes.
Now, you asked some questions about gloves and prints. If, with regard to gloves, did you ever try to take any prints, fingerprints, off any of the gloves in this case, sir?
No, sir.
Were you aware that there was one glove that had little, if any, blood on it in this case? Were you
I'm
aware
sorry,
that?
had-
Were you aware that there was one?
Sustained.
Were you aware that there was? Were you aware that there was a difference in the amount of liquid on the gloves in this case?
No, sir.
Well, he's indicating he's not aware of that fact.
No.
Or that is a fact.
Thank you. With regard to, Mr. Darden asked you some questions about a person wearing a glove and wearing gloves. If a person didn't have a glove at the Bundy scene, it's very likely that you might find a fingerprint. Isn't that correct, sir? They touch certain surfaces. Isn't that correct?
Sustained.
If an individual had a non-gloved hand and they touched the railing that you saw at Bundy, it's possible that you would get a latent print. Isn't that correct?
It's possible, yes.
All right. Just as you found a print from Detective Phillips. Isn't that correct?
Yes.
All right. Now, if an individual had suffered a cut on their hand was bleeding, and they touched an area like a railing or something conducive to a print, you might find a bloody print. Isn't that correct?
Might.
And if a person were bleeding and they touched up against the wall like this stucco you were talking about, you might find some blood on the wall. Isn't that right?
Mr. Stanton, beyond the scope of this.
Well, yeah, you didn't find any bloody fingerprints out there, did you?
There were none, that's correct.
There were none, were there?
Right.
It wasn't Mr. Simpson's job or his representatives to tell you whose prints to collect, was it, sir?
I'm sorry.
It wasn't Mr. Simpson's job or his representatives to tell you whose prints to collect, was it?
Mr. Stanton,
Oh, yeah.
Mr. Stanton. We know who he works for, counsel. We know who gave him the directions.
You're right. You were asking questions about Mr. Cole Brown Simpson's sisters. Do you aware they live down in Laguna Beach in Orange County? You aware of that?
I don't know where they live.
Oh.
Thank you very kindly, Your Honor. Thank you very much for coming.
All right, Mr. Darden, do you have any recross?
Did the defense ever ask you to do any additional comparisons, sir?
No.
Oh. Anything more?
Oh, no, nothing else.
All right, Mr. Aguilar, thank you very much, sir. You're excused, and let me return to you lift card 10 of 17, and the court will substitute the photocopy back both sides as 1324, and I'll give that to Mrs. Robertson. Mr. Aguilar, thank you very much, sir. All right, let me see counsel at the sidebar without the court reporter, please.
Sanctions, 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 sanctions. Just give us some sanctions, Judge.
All right, ladies and gentlemen, good news and bad news. I'll let you contemplate that concept for a few moments. I don't know if I should tell you the good news versus the bad news. And I can't figure out which is which at this point. The good news is that the defense tells me that if we go according to schedule, and of course, depending upon the variabilities of cross-examination, they anticipate calling their last witness on Monday, August the 28th, which is the week after next, the Monday after week after next. That's the good news. And I've asked the prosecution to begin scheduling their rebuttal witnesses for the week of August the 28th. So there's light at the end of the tunnel. That's the good news. Bad news is the witnesses who are scheduled next in order are from out of state, and we've had scheduling difficulties, and we're not going to be able to present you any further witnesses today and tomorrow. So you're going to have a long day tomorrow to, and I've told the sheriffs about this, and hopefully we'll use the time to finish up any personal errands that you have, any additional trips to Target and all of that. So we'll try to see if we can't get you out to the beach for an extra day or some other activity. I apologize to you, but as you know, as I mentioned to you when we started the case, these things happen. There's scheduling problems. Also, there's a legal issue that I need to address with the lawyers that my anticipation is it'll probably take me personally perhaps 20 to 30 hours of working to prepare for that hearing. So while you are taking care of personal business and going to the beach tomorrow and all of that, I'll be here working as usual. So it's not that we are sitting around wasting time. We'll also take the time for the remainder of today to take care of some other legal issues, and we'll put the time to good use in your absence. But we just don't have any other witnesses to present to you this time. I'm sure you understand this has been a long trial, and sometimes when you have witnesses coming from far distances, it's hard to make these arrangements, and that's what's happened to us today. But there is light at the end of the tunnel. I've told the lawyers that we need to pick up the pace a little once we get the witnesses here, because I'd like to see this jury, as it sits today, decide this case. All right? Remember my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, conduct any deliberations until the matter has been submitted to you, or allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until Monday morning, 9 o'clock. All right? We'll stand in recess. Mr. Cochran, Mr. Neufeld, Mr. Scheck, Mr. Blazier, people represented by Ms. Clark, Mr. Goldberg, Ms. Lewis. Jury is not present. Counsel, the record should reflect that on Friday evening, August the 18th, the court, in the presence of counsel, Mr. Douglas, Mr. Scheck, Mr. Neufeld for the defense, and Mr. Hodgman and Mr. Yokelson and Mr. Fairtlow on behalf of the prosecution, in the company of the investigating officers, went to the Bundy crime scene to determine whether or not the conditions were satisfactorily adjusted so that they were substantially similar to the conditions as they were on June the 12th, 1994. And after approximately an hour at the crime scene on Friday evening, after extensive discussion, comparison of photographs, modification of lighting, et cetera, the prosecution chose to withdraw their request for a crime scene view at nighttime, and as a result, the court canceled the viewing that was scheduled for Sunday evening, August the 20th, and that's my recollection of what occurred. Any comment as to that particular issue? Submitted? I just wanted the record to reflect our activities of Friday evening.
Just so the record is clear that the court made every effort to substantially replicate what occurred, and the critical factor was a light that was near the gate where the body of Nicole Brown Simpson lay. And once that had been repaired, the decision was made.
All right. The problem being is that the photographs really didn't give us a clear angle or clear appreciation of the angle of that light. And as we discussed on the record last week, photographs are dependent upon the speed of the film, the aperture, the exposure, and so it's hard to, from the photographs themselves, recreate the lighting conditions as they existed that evening. And so there was a defense objection to begin with, and then the prosecution withdrew their request. All right, Mr. Scheck, anything else on that
Yes,
issue?
I think that, but the court's concern that the lighting be restored as much as possible to the condition as it was that day was a wise one, because when we did do that, I think it was clear to all parties that there was substantially more illumination on our visit last Friday evening than there was the previous visit. And that was more in keeping with what is depicted in the photograph taken that evening by the police.
Well, you objected, you won, so I guess there's
I
nothing
understand.
much more to say, is there?
No, I just
All
wanted
right.
to make the facts clear.
All right. Any comment on that issue on behalf of the people?
Only, Your Honor, briefly, that the neighbor who lived next door to Ms. Brown indicated that the lighting as it existed on the night, on this past Friday night, was considerably brighter than it had been on the night of June the 12th. And he said, according to his memory, that it was not representative. Detective Lang similarly indicated that the lighting no longer represented its condition, that it was considerably brighter on Friday night than it had been.
All right, since the court could not substantially recreate the conditions, then I think this is the appropriate decision. All right, this morning, the court directed counsel to confer with regard to the next witness, defense witness, who is Mr. Regals, is my understanding. And Mr. Goldberg, you're handling that matter?
Yes, Your Honor.
All right, did you have the opportunity to speak with Mr. Blazier and Mr. Regals and discuss the matters you needed to address?
Yes, I did. I wanted to address a couple matters before the court, before we started. If I may do so.
Yes.
Number one, Your Honor, Mr. Blazier, I believe, and maybe it was a miscommunication, had told me that Mr. Regal was not going to be testifying to anything that related to the notes that they turned over within the last couple of weeks in discovery. And I believe...
What was the subject matter of Mr. Regal's notes?
Well, they covered a wide range of topics. The only one that's relevant for what I'm about to say is notes as to the August 26, 94 Bronco search, which, and Mr. Blazier could probably give us. Okay, there are some August the 26, 94 Bronco notes, and then I believe there's another little sketch that was provided from a viewing in April of the Bronco.
April 95?
Yes, Your Honor, of this year. And I did not know that he was going to testify to that because of the, excuse me, it looks like the date on that is March 14th of 95. I did not know he was going to testify about these things because Mr. Blazier seemed to indicate to me that he was only going to be talking about things that had to do other than the notes. So there has been, without any question, a discovery violation here, in my view. I mean, these notes are old, and they were just turned over to us very recently. However, I don't think that I can say in good faith that these particular matters, as I understand Mr. Blazier's offer of proof this morning, would require a delay as the sanction. And therefore, I'm not requesting that because Mr. Blazier has represented to me that the only thing about the Bronco that Mr. Regal is going to be testifying to is whether or not he could see certain stains on the door. And if that is true, I can't legitimately say that I need more time to prepare on that particular issue if that is all his testimony is confined to. However, we would be requesting a sanction for the discovery violation in the way of a juror admonition. And this just came to my attention this morning, so I didn't know that I was going to be addressing Your Honor on this. The second issue is as to the scope of Mr. Ragel's testimony. The people have previously argued to the court in a number of different contexts, citing the Supreme Court case of People versus Koresh at 52 Cal 3rd 648. In fact, I think I discussed it a little bit last week in another context with respect to Michelle Kessler. The language saying that we agree that it was not material to any issue in this case. The defectiveness of the evidence gathering techniques in this case, if any, is not measured in comparison to other purportedly superior techniques. In other words, that the issue when we're talking about forensic evidence and evidence gathering techniques is what techniques were used. Were those techniques defective in any way so as to undermine the probative value of the evidence? Looking at other techniques that could have been used or other hypotheticals as to how someone else would have gone about investigating a crime scene, while it may be interesting, does not, in the words of the Supreme Court, assist the jury in determining to what extent the method employed actually produced probative elements, nor can it help the jury assign a weight to the evidence. My understanding of Mr. Ragel's testimony is that he wants to testify to how the crime scene should have been processed, techniques that should have been used, techniques that he's critical of, and so on. And I just think that that kind of wide-ranging inquiry into the overall competence of the crime scene investigation is not probative in light of this language, unless it is limited and tied to specifically what effect this could have had on the evidence that we actually have produced in this trial. And I don't think that that is the intent from my conversation with Mr. Ragel of this testimony. I don't think that he's intending, if I'm understanding what he told me, to say, okay, the effect of this is that now the DNA results are less reliable because of the following. Because he is not an expert in DNA analysis. So just to say, well, I don't like the way that they collected it without being able to tie it to an effect, in my view, and I think in the California Supreme Court's view, is not probative and should not be allowed. So there should be at least some strict limitation on his testimony, if not out and out preclusion of his testimony, depending on exactly how they want to structure the testimony.
Blazier?
Morning, Your Honor. Let me first talk about the purported discovery violation. This is a one-page, actually half a page handwritten note of about the Bronco when they went out there in March to look at it. There were no testing done. Mr. Ragel did nothing except look. This is not discoverable under Hines or any of the other cases. He doesn't intend to rely on this particular note. All he's going to testify about is that the specks that Dennis Fung identified as the specks of blood that Mark Furman described can't be seen, or most of them can't be seen unless the door is open. That's the total of his testimony on that point. This note is not even discoverable. I think it was given to them last week anyway. It's less than half a page. As to his testimony in general, they have presented through all their witnesses opinions as to whether these crime scenes were processed appropriately or competently. All Mr. Ragel is here to do is to testify as an expert on crime scene processing techniques, to testify as to whether the techniques used in this case were acceptable or not, were competent or not. That's all. It's rebutting the opinions given by all of their witnesses about the appropriateness of the way they did certain things. Obviously, if he testifies that it's inappropriate to put wet swatches in a plastic envelope, it's difficult to express that without expressing what's the right way, how are you supposed to do it, what do you need to do to protect the evidence, to protect the integrity of the evidence. I'll intend to spend a lot of time on techniques that weren't used in this case. His primary focus of his testimony is the techniques that were used in this case and whether they were acceptable or not from a forensic or investigative standpoint.
Well, to respond to the last issue first, it may be possible that the court simply has to rule on a question-by-question basis as to Mr. Ragel's the propriety of Mr. Ragel's answers. Because I would agree with counsel that at least in the one hypothetical example that he gave, if he's saying is it proper to put items in a plastic bag and what kind of effect that could have, that probably would be a proper subject of testimony. But then if you ask the next question, well, what other techniques can be used, it may or may not be crossing the boundary into the territory that I think Koresh prohibits. So maybe this is more in the nature of simply trying to state what our position is up front, and maybe Your Honor does simply have to rule on a question-by-question basis on those kinds of issues. As to the discovery violation, if I may, Your Honor, and I'm sorry because I did not know this issue was going to come up until literally a few minutes prior to addressing it in court. But on this one page, it is, as counsel represented, a page indicating his observations, and there's what purports to be a little sketch of the Bronco on it. So it clearly is a report of observations of experts that is discoverable. What I should have brought to the court's attention that I failed to is that this also indicates that there were 12 photos, and they have photographic numbers.
With USA Safe Pilot, I can say.
And I seem to recall that when this occurred, Mr. Regal did take photographs, and I don't have the photographs of this. So the photographs are a form of documentation of an expert, of an observation.
Excuse me, Mr. Goldberg, were you present for this
Yes.
viewing with Mr. Regal?
And I had no idea what they were up to. I mean, you have to, it's difficult to get into the conspiracy mode sometimes to figure out what's going on, because they were looking at little cracks in doors. So I just thought, these guys are Meshuggah, and didn't know what they were up to. So I wasn't particularly watching that carefully what they were observing. But at any rate, Your Honor, what? Well, this is Los Angeles. It's an L.A. pronunciation.
Yeah, but somebody who's a Goldberg, Mr. Goldberg.
Yeah, well.
But having grown up in the Los Feliz district, I've heard that expression before.
Okay. At any rate, Your Honor, I don't have the photographs, and I think we're entitled to them.
We don't tend to use any of those photographs, so
But
it's not
there's
entitled.
still documentation of what was done.
At the same time, there were several police officers there. They could have taken any pictures they wanted.
All right. I believe, as Mr. Goldberg indicated in his last comment, that the issue of whether or not Mr. Regal's testimony will go into other techniques and how far the court will allow is really a question-by-question, issue-by-issue, subject-by-subject determination the court has to make. So I take that as simply that the prosecution wants the court to be on notice to expect those issues as they come up. I take that as a premature objection. As to the purported discovery violation, I find no violation since the prosecution was, in fact, present at the time these observations were made. They had equal access to those observations. They could have taken their own photographs. They do have the notes and plenty of time to prepare for cross-examination of Mr. Regal's. None of this is, to my recollection, going to be rocket science. So I think we can proceed. All right. Lastly, counsel, I spent some time over the weekend dealing with the offer of proof regarding the Furman tapes, so-called, and I had great difficulty dealing with it. And Mr. Cochran, do you want to address that issue?
Yes, I will.
Tell me what to expect.
Yes, let me tell you what to expect. And I apologize to the court. As the court knows, I was out of town. And I'm not totally sure what Your Honor has. Did Your Honor receive a redacted copy of the original tapes turned over by Messrs. Schwartz and Regwan? Is that correct? And I understand that Your Honor was not given the first 48 pages. Is that correct? Of the transcript?
Something was given to me this morning.
Yeah, I brought that down for you this morning. And let me see if I can explain the confusion and tell you where we are and how we straighten it out. Of course, the court is aware that we over-optimistically said we'd be able to get you a verbatim, word-for-word transcript of this pretty quickly. That is now finished. And by the end of the day, Mr. Douglas will walk through those doors with hopefully a redacted, verbatim transcript and an offer of proof that's key to our transcript. With regard to Ms. McKinney's transcript, some of the pages are off. We had discovered this in North Carolina. Also, as the court is aware, the first tape had been taped over, and she had the first 48 pages. Apparently, you hadn't been given, and I discovered that last night when I returned, and I gave those to Your Honor's clerk this morning.
Well, I spent several hours this weekend. At first, it was so incoherent, I couldn't figure out what was going on. But I figured since time was of the essence, I ought to at least try to make some sense of it.
Sure.
And after going through your offer of proof, trying to correlate it with the tape and with the transcript, I couldn't do it. And I don't think it's my obligation to spend my time going through 12 hours of tapes looking for a particular excerpt.
It certainly isn't. These items are on those tapes. It's important that you be able to hear them, and I've asked the day Messrs. Messrs. Jerry Ullman, Bailey, Douglas are keying the offer of proof to the tapes and to the first transcript, of course, which is not on tape, that she did. And you'll have them by 5 o'clock today. In addition to that, you're aware that we have cleaned up all but 3 of the tapes for background noise, and I understand that by 10 o'clock tomorrow morning, the remaining 3 will be cleaned up, so you'll have those. So you'll have everything.
I'll have clean cassettes and a coherent transcript and an offer of proof that's keyed to the other.
Key to our verbatim transcript
Right.
by 5 o'clock, and the remaining 3 transcripts will be here by 10 o'clock tomorrow morning. Okay? And I apologize that the court had to go through anything that caused you any problems, because you got a flavor for it, but we want it to be so that you'll understand exactly where they're keyed directly in. We'll have it. And while we're about that, I'd like to find out, just for a matter of scheduling witnesses, how you plan to do that. Let's assume that you have the offer of proof, the transcripts and everything tonight. You also have our brief. We filed a brief regarding the admissibility of that this morning. What would be Your Honor's pleasure when we get to the 402 hearing, given that schedule that I just laid out?
Well, see, that's the dilemma, because I had hoped to spend this weekend doing all of that, reviewing the tapes and comparing it, and and then hearing argument and considering the prosecution's objections, because I didn't want to lose the jury time.
Sure.
But now it appears I'm going to have to use court time and my own after-hours time to do this.
All right, we'll be ready to try as much as we can to have witnesses to, fill in at least until you reach the point where you say, okay, let's do this.
All right, let me see counsel at sidebar without the court reporter, please. All right, thank you, counsel. Just want to make sure we have witnesses and our scheduling together. Mrs. Clark.
Yes, Your Honor. With respect to the court's order filed today concerning the difficulty in locating those passages on the tapes, I should indicate to the court that with respect to the first entitled segment of the court's order, racial epithets, all of those portions are not on tape. That tape has been destroyed. All we have is Laura McKinney's transcript, quote unquote. It's not a verbatim transcript. I believe that's the same problem that you're going to find with the incidence of misconduct.
Well, why don't we save this argument?
I'm not going to argue. I'm just informing the court that you will not find it in a verbatim transcript because there's no tape.
That goes to the weight that I have to accord it to see whether or not it's trustworthy, reliable, and should be admitted.
And it does.
So,
and all I'm alerting the court is that if you're listening for this on the tape, you will not hear it.
all right.
Okay? None of this is on tape. With respect to the verbatim transcripts, we have prepared verbatim transcripts of all of the tapes that still exist, and we have agreed with the defense, I believe I agreed with Mr. Bailey last week, to furnish them a copy of our transcripts if they would give us a copy of theirs, and we agreed on that. So
And
what
Mr.
I'd like...
Cochran just reiterated that.
Yes, and if I could also request that whatever the defense is giving to the court, they furnish us a copy of that also.
All right. All right. Let's. Is this on the tapes issue?
No, this is on the discovery. Dr. Lee, you can take this
No,
up
I
now.
wanna-
You can take this up.
I'd like to finish the Furman tapes first. We have counsel for Ms. McKinney here, who faxed to the court, and I think to counsel, a letter indicating their concern that transcripts of these tape recordings have leaked out. Gentlemen? Mr. Schwartz, good morning.
Good morning. We're here to follow up on that letter that we wrote to you. We're concerned about these persisting violations of the court order. As the court may or may not be aware, last Friday morning, the Los Angeles Times printed an article that contained a verbatim portion of our client's protected intellectual property. And furthermore, the Reuters news organization transmitted over its wires across the country for everybody to see additional portions verbatim of our client's protected material.
Do you know the source of that? Is there any court document that may be the source of that?
We suspect that it would have originated from the defense's offer of proof, but we're not sure. But the giving of this information to the media at this point in time, especially since nothing has yet even been ruled admissible, is obviously in direct contradiction to this court's protective order. There have been 3 sets of our client's materials that have been disseminated during these proceedings. The originals went to the court, and we tendered a complete copy to the prosecution and a complete copy to the defense. Therefore, the people responsible for violating the court order are here today. And this court shares with our client a vested interest in the enforcement of this court order. Obviously, our client is interested in protecting her proprietary interest. But this court has to be concerned about the challenge to its authority that has occurred. If this challenge does not go unanswered, then perhaps the dominion of the court could be threatened, and the force and effect of future rulings of this court could be affected. And therefore, we're asking this court to request the attorneys on both sides to conduct their own investigations and try to find the source of these leaks. And if they're unsuccessful by perhaps close of business Wednesday or Thursday, we'd like to ask the court to conduct an evidentiary hearing wherein Mr. Regwan and I will be able to conduct a direct examination of the journalists who carried these stories throughout their organizations. And the news shield, the shield law, will not pose a problem, Your Honor, because the shield law will not protect officers of the court from violating a court order. If the shield law is raised, then it would unconstitutionally impinge on the independence of this judiciary. And so the shield law will be inapplicable. We've done the research. It'll be a very easy proceeding. We'll just bring in a couple of reporters and ask them point blank, where did you get this information from? And they'll be able to tell us.
All right, Mr. Schwartz, do you have a copy of the defense offer of proof that was filed late last week with the
No, I don't, Your Honor. I believe that was filed under seal.
All right, my staff compared that offer of proof with the quoted passage from the Los Angeles Times article. I did not read the article myself. However, they showed me highlighted portions, and they appear to come from the offer of proof. What I'll do, Mr. Schwartz, I will, first of all, I'm going to direct counsel on both sides to file all documents with regards to this issue with the court under seal. Secondly, Mr. Schwartz, I'm going to direct that the clerk of the court give you a certified copy of the offer of proof so that you can compare it with the news leaks, and we'll see if we can at least pare down what the probable source is.
Okay.
All right, and then we'll take it from there.
Okay, thank you. Would you like me to reappear after I've had an opportunity to review the offer of proof?
Yes, you can notify the court of your position by mail.
Okay.
As we're going to be busy with other witnesses.
Okay.
All right, thank you.
Thank you very much, Your Honor.
All right. All right. Anything else before we start with Mr. Regal?
Just one other thing, I just got a call from Mr. Jones with regard to Dr. Reichardt. Apparently, he is scheduled for tomorrow morning. We cannot get him here today at all. Neither he nor his lawyer, so
Well, I think we're being optimistic if we think we're going to finish with Mr. Regal today.
hopefully that will not be a problem. That'll be tomorrow. Okay.
And I'll be ready tomorrow.
All right.
Maybe I want to bring up the Dr. Lee matter before, maybe after we break, or maybe just before we begin in the afternoon, because I think we have to set the discovery issue straight. We had some discussions about that this
All right. You handed to the court, Mr. Scheck, a number of copies of your upcoming photo boards,
Yes.
most of which look very, very familiar to the court.
Yes, Your Honor, what has happened is that Dr. Lee, I guess over close to a month ago or so, filed a report in this case. We've turned over all the notes. We turned over to the prosecution Xerox copies of photographs taken at Albany and other photographs that they previously had from Dr. Lee, and photographs from these boards, many of which are their own photographs. I should note with respect to the Albany photographs is that they had a photographer and they had a witness on the scene for everything that was examined in Albany, so they have their own copies or an opportunity to look at those pictures. In any event, there is one, I believe one, maybe two, but one more board that is not reflected in those copies, which I know is arriving today, that is just a blow-up of other pictures that are contained within those boards, and other pictures that the prosecution has had available to it. Mr. Goldberg this morning, now the other thing is that there was mention of access to Dr. Lee and opportunities to talk to him and find out about his testimony, and that was broached by Mr. Hodgman and others at the crime scene. What you should know is that the prosecution, we have a difference, and I'll just chalk it up to misunderstanding, that I had communicated to Mr. Goldberg that when the prosecution talked with Dr. Lee, because he is always available to talk with the other side, that's his policy, it's a standing policy, that I wanted to be on the line so that we could have a record of it. He doesn't recall it, and that's fine. I don't want to dispute that. It's not an issue. They did, I believe, they sent some questions to him. He was in Indonesia. They spoke with him about 2 or 3 weeks ago. Then
that man sure gets around, doesn't he?
He does. Then Mr. Hodgman and Mr. Goldberg, I believe, had a fairly extensive conversation with him either Saturday or Sunday. They can tell you best. I know from Dr. Lee that Peter DeForest, the rebuttal witness, went over those boards with him on Sunday.
Wait, rather than tell me all this history, what's the bottom line?
The bottom line is they are saying to us this morning that unless that they demand photo pictures of every photograph that we turned over in the Xerox materials. We only have one set of the Albany photographs. I offered to let them have any particular Albany photograph that they wanted. I have for them photographs of all pictures on the boards. Plus, they have a copy of the boards. Plus, Dr. DeForest spent 4 hours with Dr. Lee in his home yesterday.
No. Absolutely not. I don't care one bit about these Xerox copies and what they want. And more discovery and trial, bull. We are done for today. You did this to me, sir. You pushed me over an edge when you said those words. They want Xerox copies of everything. Well, first off, before you present anything, you give them, everybody should have copies of everything. This is ridiculous that we are going through this. Ridiculous. You walk into a court, you have your copy. You have a copy for the prosecution. You have a copy to submit as evidence. What the heck? What in the heck is going on? They never know where they're at and what they're doing. And Sir, please. Anyway, we're going to stop here today, and we're going to continue tomorrow. I hope that you guys have a great night. Thank you so much for coming out, guys. I really appreciate it. See ya.